Welcome to Bill the Lender podcast, devoted to educating you on a variety of financial subjects with an emphasis on real estate and real estate finance. Please click the button to subscribe to my channel so you don't miss an episode. Then like and share your favorite episodes. Everybody, and welcome to today's podcast. I'm Bill Rodriguez with Cornerstone Home Lending, and I'm here with Sam Kornfeld, and he's with the Keep Law Firm. Sam is a Colorado native and grew up along the Front Range. He received his undergraduate degree from Colorado State University and a law degree from the University of Wyoming. After graduating, Sam started his legal career in litigation, but grew frustrated that many cases could have been avoided in advance with proper planning. Estate planning cases were often the most troubling because the fight was between family members, which is why Sam decided to change his practice and focus on estate planning to help families avoid the problems he had seen. Now Sam works in both Colorado and Wyoming, where he maintains a focus on wills, trusts, and estate planning for young families with minor children, and also works with firearms rights, restoration, criminal record sealing, and engagements. Sam has a passion for helping individuals protect themselves and their families. And when he's not practicing law, Sam also dedicates his time as a member of Kiwanis International, volunteers as the board chair for the Academy of Arts and Knowledge Elementary, and serves as treasurer for the Byron White Inn of Court. So welcome, Sam. How are you today?
Thank you. Good to be here, Bill.
So, Sam, you and I talked about a few things, and we came up, I think, with a lot of great things that we're going to cover, because I feel like estate planning is a topic that not a lot of people like to talk about. So we're going to talk about some common myths today, and some of the most important reasons to complete an estate plan, and some of the frequent mistakes that you see. Is that correct?
Yeah, for whatever we have time for. Attorneys love to talk, so I could spend the whole time we have on just one area if we let it happen. So we'll see
Well,
what we get through.
and we may break this up into multiple segments, because I really feel like this is a valuable topic that not a lot of people really dive into, because most people, let's just face it, they don't necessarily like to talk about, death.
It is not pleasant, and it often gets short shrift as a result. And people think, well, I can save that to later. I'll put that off.
Right. So let's start at the beginning. Let's talk about some of the most common myths associated with developing an estate plan.
I think that's a great place to start. And the biggest myth out there is that estate planning is just for the rich or the elderly. And the plain fact is that young families with minor children have the most to gain from doing an estate plan to ensure the safety and security and comfort of their kids should something happen to them, whether it's actual death or just incapacitation. And, everybody can save a little bit of money from proper estate planning when we look at the numbers. The probate process in Colorado can be from anywhere 2 to 3% all the way up to 5%. And if you have a modest estate, $250,000 to $300,000, you're looking at $9,000-$10,000 in that probate, and you can create a trust for half that. And if you own a home anywhere near the northern Colorado area, you're already at $500,000 in assets. So you can benefit financially regardless of your wealth level there. And accidents and emergency. Oh, go ahead.
I was going to say, you bring up a great point, because, Coloradans, actually all Americans, have seen more asset growth just in their real estate base over the last 5 years. And so if they haven't updated or even thought about an estate plan, you do bring up a great point. Like that is reason enough just to have that conversation.
And you would actually know better than I about what the median home price is right now across the Front Range, but I think we're close to 500,000, if not beyond.
Yeah,
So,
it goes by county, but yeah, I mean Boulder County is, up over 1 million for a median price. Longmont, where I live, that's up in the 600s now, but that has grown significantly even over the last 2 years.
yeah. And then
So,
the final nail there is, accidents and emergencies are a danger in everyday life. So you shouldn't put off your planning until you're elderly, assuming you're going to make it that far. In our day and age, that's pretty presumptuous, I feel like.
well, right. I mean, a lot of things can happen, and I mean, you mentioned some of the biggest challenges that you saw were, people fighting amongst themselves. So tell me, in terms of the basics of an estate plan, what should that really accomplish?
Well, when we look at the reasons for an estate plan um, that people talk to me about, number one is if we're back to safety of the kids. Um, a lot of people don't ask themselves the question before we meet, what would happen to my kids if I don't come home tonight? And the sad fact is, if the police show up and there's a babysitter or somebody there temporarily, or they're just at daycare, they are the emergency number listed for their child. So the police won't know who to call. So that child might end up in foster care, at least temporarily. So we
Wow.
want to prevent that from happening. And we also want to make sure that we set some parameters, even if they don't pass on. Uh, I guess I'm going to cross over here and discuss some mistakes I've seen. But a lot of times
Sure.
people think, oh, I've done a will, I've listed a guardian in my will, I'm all set. But that will is only effective once you actually pass on. If you're simply incapacitated in the wreck, the will has no effect. So
Oh, that's a good
um,
point.
you want to have additional documents done by a thorough estate plan in order to protect in both those instances. The next big reason I see is
So wait,
protecting
wait.
one.
Let's tell
Oh,
our listeners what would be the basics of qualifying that plan in that type of situation there. So you've got, is that a medical power of attorney? Is that what is in that proper plan right there to plan for
well,
that family piece?
yeah, and that would a lot of times depend on that specific situation. Now, as far as what I consider essential in a plan just for an individual, would be at least a will, would be a durable power of attorney, medical power of attorney, advance directive or living will, a final disposition, and potentially a voluntary directive, and a trust, depending on what concerns and goals they had. Now, as far as protection of the kids, we'd also want another medical power of attorney just for the kids, so that can be assigned. But we'd also want a nomination of guardianship outside of the will for that incapacitation. Probably also a temporary nomination for that area in between when the judge hasn't set a permanent guardian yet, but we need someone to step in and watch over the child and do that. And potentially also confidential exclusions. If you have particular family members that you wouldn't want raising your kids, we'd want to put that in writing as well so they can't step forward and attempt to become the guardian, even if it's some misguided sense of altruism that you don't agree with their politics or the way they raise their kids. We want to prevent that from happening.
And you bring up
Well,
a good point there because you can't do anything beyond the grave. And there are a lot of folks that you mentioned altruism and these types of things that may feel a righteous sense of justice or trying to do the right thing. But you're absolutely correct, and you bring up some great points. And most importantly, most people are only thinking of death. They're not really thinking of incapacitation, which is I hate to say it, but probably more likely, right?
Well, you are correct. That is much more likely, especially when you're young, but just in a daily sense, more likely to happen. So that is where I'm going to put half the thought and horsepower behind the plan is just what happens if you need assistance, not if you've passed on yet.
Very good, very good. So we're covering a lot of our questions here just broadly in this conversation, but let's dive a little bit more into the frequent mistakes because in your bio again, you talk about a lot of things that you've seen in terms of families coming against and infighting. How do you? I mean, how would you protect against that? I think I know the answer, but how do you see the best way to protect against that?
Yeah. Well, a lot of times it's steering people away from things I've seen go wrong. And those common mistakes I see individuals make when they come in, say what they want, and either they do it online or the attorney just does what they say without counseling or educating is number one, they, I see it too many times, they try and force conflict. They think they're going to try and force delinquent son or daughter to either work together or grow up finally. So they put them in positions of authority that require them to make decisions in their estate documents. And that just breeds conflict, as you can imagine.
Mhm.
Um, Another big one is they don't update their plans. You know, they move, kids grow up, new kids are born, property sold and purchased. So when that plan goes to be used, it's outdated. Uh, Another big one. Oh, you have a
So
question? Go ahead.
how often then for our listeners should people be thinking of updating their plans? Is that like every time I make a move, every time I make a shift? Are there family dynamics that are driving that? What are some of those? Because I know beneficiaries is could be a big holdup to an estate plan.
It could. And of course, anytime you've got a major life event, you probably should review the plan to see if it needs to be updated. That could be a move, child goes to college or is born. A divorce is a big one I see where people get separated, the divorce is finalized, and think, finally I'm done with that, only to discover that their estate plan still lists ex-wife as the beneficiary. Um, but as a matter of course, I like to reach out to clients at least every 3 to 5 years. That's the term I want to look at, just as a reminder to check in.
That is a great piece of advice and also a big mistake to avoid. What are some of the other mistakes you mentioned naming somebody to and I never even thought of that to influence them or to force them to show up in a different way. How would you advise your clients to avoid that?
Well, the most important aspect whenever we're selecting somebody to take a role in your estate plan, regardless of whatever that role is, executor, personal representative, medical power of attorney, durable power of attorney, is trust. Do you trust this person? And if you don't trust them to pay the bills for you if you're incapacitated or to protect money if you're gone, don't require them to rise to the occasion and suddenly start being fiscally responsible with money. Uh,
That's a bad
and
plan, it sounds
yeah,
like.
it's a bad place to be. And I see it shockingly often that the parents envision this hallmark moment where Johnny's going to finally, you know, put down the bong or whatever and rise to the occasion because he's been bestowed this gift. and required to take care of the family farm or whatever. And it's just not going to happen. And if there are other siblings who are then waiting to get their share until Johnny takes care of the property and makes it income earning, or lets him live there rent free and take care of it until he moves out and sells it, and now the property has low value because he hasn't maintained it, it breeds a lot of conflict.
Yeah, that's huge. So, I mean, we've talked in talking about some of the frequent mistakes. We're kind of covering the more important reasons to complete an estate plan. But what are some of the things that fly off the top of the handle that you have conversations with your clients with every day that we may not have covered?
um well, so, we've covered safety. Dignity is another big one.
Let's
You
talk
want
about
to
that.
set Yeah, you want to ensure that your own dignity and comfort are set forth for. And everybody has a different avenue on the spectrum as far as where they fall. Keep me alive as long as possible is a lot different than don't string me along. And you don't want to force your family to have to make those fraught choices for you. You want to lay out what you want ahead of time. And, you know, it's another area of conflict. And a lot of people might be familiar with the Terry Schiavo case out of Florida. And that's a real good example because not only did Terry Schiavo have a medical power of attorney, she had a living will. But the problem, it is only discussed certain treatments. It didn't discuss hydration and nutrition. And that's what the battle ended up being about.
Wow.
Husband thought that she would want to keep going, and parents thought no, she wouldn't want to be strung along like this. And they had a nationwide court battle ending up about it because the documents weren't thorough enough to really ensure what dignity she would have wanted.
So this is an interesting point to me because I feel like estate plans can be overly complicated, but if they're not complicated enough, then situations like this happen. How do you ensure that as far as avoiding mistakes?
Well, it is a little bit of an art form, and you just focus on number one, what's likely to be a problem, and number two, what you've seen be a problem in the past. So, and a lot of times that involves just reading cases that come out and seeing what the fights are about and going, that is something I should address. That is something I need to ask clients. How do you feel about tube feeding? How do you feel about amputation? How do you feel about ventilators? Getting all those out of the way so that you can put that answer in there. And the goal in an estate plan is not to run through a checklist so the person can go down to number 156 and say, okay, this is the situation we're looking at. What did mom or dad want? It's laying out a grid where somebody can say, well, we're closer to here than here, and this is what mom and dad would have wanted. So this is what I'm supposed to do in this instance. So it's
That's
really providing guidance, is what we're doing.
yeah, sort of the you can't cover everything, but situationally speaking, this is where we should end up. It's almost like situational awareness in some regard.
I think that's a good way to look at it. You can't plan on every eventuality, but you can look at the variety of choices and likelihoods and focus your efforts there.
Well, cool. What other things do you think people should know when they're considering an estate plan, whether they should do it or not? What are some of the compelling reasons? What would be two reasons why you would say, if you haven't thought of an estate plan, which we
Mm.
know less than what is it, less than 30% of Americans actually have a plan? I mean, this is a topic that is wide open for you guys
Yeah.
because there's a huge need. So, share with our audience why, if you're a new family and you just bought your first home, why should you think about that?
And I think that is a great segue into talking specifically about trusts. And, everybody hears about trusts, but people rarely understand what it is and what it does and can do for you. And in regard to little ones, a big thing there is keeping things confidential. So, a will that is submitted for probate is a public document. So that means there are unscrupulous people out there who can watch those court filings and see if somebody relatively young is going to be inheriting a big chunk of money. Now, of course, they won't actually get that money until they're of age, but they can spend that time getting buddy buddy with them. So they can try and get them to part with that money, either as a gift or maybe an investment in a business. So
Wow.
we want to keep that confidential. Another thing would be access. If you just have a will or no will at all your money and property is going to be tied up in probate, which means the judge is going to have to authorize payments out of that for the benefit of your kids for whoever's taking care of them should something happen to you. If it's in the trustee themselves has access. So they can reach in there and pay for food, clothes, soccer, music lessons without getting judge approval to do so. Another big one I see is remarriage. So if something happens to you and all your money goes to your spouse outside of a trust, spouse gets involved with a new boyfriend, girlfriend, and they end up squandering a bunch of the money, or they get a divorce and they haven't kept that money separate, they might end up with half that money. So you'd want to protect that money for your kids to make sure your spouse doesn't get involved in a relationship while they're depressed over your loss. Fourth would be rules for the kids themselves. So with a will, you can say what happens then and there, but a trust can go on into the future. So you can set extended rules for how and when the kids would take money. So you can say, I don't want you getting any money until you're 28 unless you're using it to start a business, get an education, or buy a home. Conversely, you can also set limitations. So you don't get any money if you're having a substance abuse problem, if you have creditors coming after you for money, if you have a pending divorce. And then we can also just set it far into the future to say, okay, you get a certain percentage when you're 25, and then you get a certain percentage when you're later, maybe 30. And in hopes that you realize that you maybe squandered the money you got at 25 and you learn a lesson. Oh, I got to be more careful and diligent with investing this money so I don't lose it.
So, really, what I hear you saying is that the estate plan allows you to um, enforce and maybe enforce, but support the values of the family structure long beyond the grave, which is fantastic. And it really sounds like we can probably bring you on for another episode just to talk about trusts
Yes.
because you can dive into that, and we see trusts all the time on the mortgage side, and it's usually in association with buying a home that's been marked out, or the family business was investment real estate. We see that a lot too. So all really good stuff. And but I want to take a moment to thank you for being on today, Sam. You've given some really great stuff for folks to think about. Tell our audience one way or the best way, if they have additional questions after seeing this episode, how can they get a hold of you?
Well, they can reach me by email. That's through my website, sam@keeplawfirm.com. And you can call me directly. My phone number is 970-481-7705. I try to be one of the attorney who brings down barriers. So if I'm available, I answer my phone, even if it's a new client. Now, if I'm not available and I'm meeting with someone, you will get the staff, but I try to be the initial point of contact if I can. A big part of my mission is educating people. And I feel like that's one of the major mistakes attorneys make when they're doing a plan. They send a packet of documents to a client, have the client fill out what the client thinks they need, having no education about what an estate plan should do and can do. And then they have a 15-minute visit with the client and build the estate plan off that. And that's based off the erroneous mindset that the goal here is to create documents. And that's not what we're trying to do here. We're trying to create a plan to serve certain goals. And the documents are a byproduct of that, not the end all reason we're doing so.
Well, that's one of the big reasons why we brought you on, because this podcast is dedicated to educating consumers around all matters financial service related, with an emphasis on mortgage. And with that, I will close us out and thank you for being a guest today, Sam. Appreciate it.
Thank you, Bill. It was great talking with you.
Please note this material is provided for general purposes only. Sam is not serving as your attorney, nor have you and he engaged in an attorney-client relationship. Laws may vary in different circumstances and sometimes change. Tiny variations in the facts, known and unknown, often can change a legal outcome or an attorney's conclusion. You should not rely on general information as specific guidance to you. Please consult with your attorney for advice and/or representation.
Thanks for listening to Bill the Lender podcast. For questions, please reach out to me at 303-877-6323.